Hello everyone, welcome to the June version of the Land Use Case Law Update, and thank you for joining us. It looks like we probably don't have all attendees, but we'll get started. We're going to do a few minutes of introduction, and then Phil will begin his presentation. Phil Olbrechts has been partnering with MRSC to do these trainings twice annually for the past several years. And my name is Jill Dvorkin, and I'll be presenting along with Phil today. Phil is a very experienced land use practitioner, and we are very happy that he is willing to do this update. He is city attorney for 2 jurisdictions, hearing examiner for 13 jurisdictions, land use counsel for 2 jurisdictions, and he's also the editor of the short course on local planning. And again, my name is Jill Dvorkin, and I am a legal consultant here at MRSC. Prior to that, I was a deputy prosecuting attorney at Skagit County practicing land use. So before we begin, I'll walk you through a short tutorial on the webinar software. You should see a toolbar alongside your screen. To expand or collapse this toolbar, click on the orange arrow. If you'd like to listen via the phone rather than your computer, you can click on the microphone and it will prompt you with instructions. And if you'd like to submit a comment or a question during the webinar, you can click on the yellow pen and submit that. We will try to answer questions at the end of the webinar. It's likely that the content will go through the course of the hour, but we'll stick around to try and field some questions, and if we don't get to them, we can respond to you in writing. And if there's technical difficulties, please call MRSC's front desk. The number is there. And at the end of the webinar, once we've ended it, it'll prompt you to a survey. And for any attorneys out there, you can enter your bar number in that survey, and we will submit it to the Bar Association. And if you don't get it through there, you can always email us or just go to the WSBA website directly. I imagine most of you are familiar with MRSC, but for a refresher, we offer research and consulting services for Washington local governments at no direct cost. We have a team of legal and policy consultants. We have a research librarian. We also maintain an extensive website with topic pages and some online research tools. And we also offer training opportunities like this throughout the year. And today, Phil is going to cover a case law update, cases that have been decided since the last case law update in December. And I will cover a couple cases that were decided previous to that, Reed versus Gilbert and Whatcom County versus Hearst, and provide some updates on what's happening with regard to those cases now. And with that, I'll hand it over to Phil.
Okay. Thank you, Jill, and welcome back, everybody, to our biannual case law update. And you probably noticed by now we're doing something a little different today, in that Jill is doing a sort of an update to the case law update, which I thought would be a really kind of a cool regular feature to have, where Jill would basically kind of let you all know what cities and counties are doing in response to the case law that we've been covering in these webinars. I mean, obviously MRSC is very well situated to, with its access to the materials and communications with all the cities and counties of the state, to see how cities and counties are adapting to the latest requirements from our Supreme Court, appellate courts, and the state legislature. So it's, as I say, probably a regular feature. So around 11:35 to 11:40, Jill's going to wave a little 5-minute card in front of me, and at that point I'm going to talk 3 times as fast, and we'll get to her presentation and get that going as well. So I am actually looking forward to today's webinar as well, because we have some really interesting cases, actually just 4. There have only been 4 major land use cases issued since the last time in December, but 2 of those, the first 2 I'm going to cover, include a lot of very useful information, which I think you'll find helpful in your daily activities and that kind of thing. Those of you who've done the webinars before know I always like to start off with some dog picture. In this case, I had to find a dog that looks a little bit like a developer, and this guy looked just angry enough to, I think, meet the bill, maybe call him Buster or something. And that deals with my second case today from Thurston County, which is essentially the consequences of politically motivated permitting decisions can cost you a lot of money, and somebody like Buster will be highly enriched by the results of that kind of decision making. And so, as I said, I'll be spending quite a bit of time on that case to kind of, go over what you shouldn't do when you're doing a permit review. More specifically, like I said, 4 cases. The first one is the one everyone's talking about, the Snohomish County vested rights case dealing with federal stormwater regulations. A bit of irony, just almost exactly a year ago today, I was doing a webinar dealing with the appellate court decision of this case. Today we're dealing with the Supreme Court decision. And as you'll note from the slides I'm going to put up on that case pretty soon, when I did it back in June of 2015, I said train wreck avoided. The court decided that federal regulation, or excuse me, stormwater mandated regulations are still subject to the vested rights doctrine. The Supreme Court reversed that and says that it's not. And so the new title of my slides is train wreck not avoided. The second case I'm going to talk about is the big Thurston County case dealing with the liability. This case just came out about a month ago or something, and essentially the Supreme Court, I think it was Supreme Court, maybe Court of Appeals, upheld a jury verdict of $12 million against Thurston County for what the court considered to be a wrongfully issued decision there. Third case, another one of our 21-day judicial appeal deadlines. This case is a little different from most. Those of you who have dealt with the 21-day appeal deadline probably understand by now that once that appeal deadline is passed, the decision is valid. You can't challenge it anymore, no matter how wrong that decision was. What Chumbley held, though, was in that particular case, dealt with a building permit decision, and their allegations that the jurisdiction hadn't properly reviewed impacts to critical areas, steep slopes in particular, on some off-site drainage. And since the building permit application didn't cover the proposed off-site drainage improvements, the court held that 21-day rule did not apply. So it's a little different result than what we're used to dealing with the 21-day rule. And finally, the fourth case deals with the state decision-making process involved in siting major energy facilities. And since that's something that most of you probably aren't going to be dealing with, although of course I know a few of you out in eastern Washington deal with the big wind farms, and down in Vancouver this case specifically dealt with a big petroleum processing and storage facility. I won't be spending a whole lot of time on that. That's where I'll be talking 3 times as fast to get to Jill's presentation probably. So okay, let's jump finally into the Snohomish County case. And I'm going to essentially, for the first 4 or 5 slides, they're going to be the same as the first 4 or 5 slides used to describe the appellate court case, because both cases run along the same track until they go in very different directions right in the middle. So, and I'll identify that for you. I think that'll kind of help clarify how the Supreme Court decision sort of departed from the appellate court. So, but anyway, as I said before, the ruling in the Snohomish County case was that federally mandated stormwater regulations aren't subject to Washington vested rights doctrine because they come from federal and state mandates. That's sort of the reasoning behind the court, is that essentially the vested rights doctrine was to prevent local communities from playing games with developers by changing their own rules on them. And that sort of policy consideration doesn't apply when it comes from the state and the feds, because of course local jurisdictions can't change those rules as much. So more specifically, there was, in this case, there was a requirement coming from the Department of Ecology through an MPDES permit that basically said, these types of permits aren't going to be subject to the vested rights doctrine, and that's what was reviewed by the court. So let's get into the specifics here in case none of that made sense to you. Starting kind of at the beginning here, the Federal Clean Water Act, that's where all this comes from, prohibits any discharge of pollutants into the nation's water unless the discharge is made according to the terms of a permit issued under the National Pollution Discharge Elimination System. So when I rattle NPDES permit, that's where that comes from. So the federal EPA, Environmental Protection Agency, is the one that's tasked with with issuing those permits, but it can also delegate that authority to a state agency. And in the state of Washington, EPA has in fact delegated that authority to our own Department of Ecology. So in August of 2012, pursuant to requirements of the Clean Water Act, the Department of Ecology, our state ecology, issues their 2013 through 2018 Phase 1 municipal stormwater permit. And this permit authorizes municipalities to, and it also regulates the discharge of stormwater to surface waters and the groundwaters from large and medium municipal separate storm sewer systems. The Phase 1 applies specifically to Snohomish County, King County, Pierce County, Clark County, and cities of Seattle and Tacoma. So these are the big players on the western side of the mountains. And that permit is effective from August 1st, 2013 through July 31st, 2018. And what that permit did is essentially it required all those local jurisdictions to put together a stormwater management plan. That's where those huge stormwater management manuals come from. That's part of each individual jurisdiction's program. And it includes the enactment of local ordinances where you're adopting that stormwater manual by reference and other documents regulating development within each permittee's jurisdiction. And that permit also contains several conditions that all those cities and counties had to abide by. And one of those conditions, S5C5, is the one that caused a little bit of problem here. The S5C5, that's the one essentially that goes into the whole stormwater management program you put together. You need to have site plans and do your stormwater calcs about ensuring that there isn't a net increase from the time that when the property wasn't developed, all that kind of stuff that goes along with stormwater review. And then attached to this condition was S5C5A3, which says that the local program adopted to meet the requirements of that last condition I just showed you shall apply to all applications submitted after July 1st, 2015, and shall apply to projects approved prior to July 1st, 2015, which have not started construction by June 30th, 2020. So what this condition is saying is that these new regulations that were, adopted by local ordinance to address the stormwater requirements can apply to permits that have been filed and vested before these regulations were adopted. That would be for that highlighted language there. And it's a pretty narrow set of applications. I mean, essentially the developer had to file their application before July 1st, 2015. That's already more than 3 years ago. And then they're not starting construction until 2020, 2 years from now. So, 95% of development projects are not going to be subject to this vesting program. But I've come across a few, especially those that are subject to development agreements with long-term vesting, where this really does become an issue. Let's see. I'm sorry. Yeah, this is the next slide I just put up is for Phase 2 permits. And I just put this up. It's almost identical to the one that applies to Phase 1 permits, except that it extends the construction starting date to 2022 instead of 2020. Everything shifted over a couple years. So the ruling of this case applies fairly equally to both. It's just they have slightly different vesting clauses, but they're, for all substantive purposes, they're identical. So for those of you who are subject to the Phase 2 permits, the smaller jurisdictions in Western Washington, this ruling applies directly to you as well, ultimately. So the issue is, does that condition that sets up this vesting scheme that's contrary to Washington state law, does it violate the vested rights doctrine that was put together by our courts and later adopted by our legislature? And let's take, we'll take another step back. What's the vested rights doctrine? Talked about this several times. I think most of you know what it is already. It generally provides that once you've submitted a complete development permit application, that you can't change the rules on that application anymore, that amendments to land use and zoning laws and development standards after the filing of that vested permit application cannot be applied to that. You're vested to the rules that were in place when that application was filed. And the purpose of the vested rights doctrine is to provide certainty to developers, to give them some protection against fluctuating land use policy. That's why our courts adopted it way back in the 1950s. At this point, the vested rights doctrine has changed substantially just in the last few years in the state of Washington. It used to apply to just about every development permit you could think of, or at least anytime someone brought one to court up until at least about 10 years ago. The courts would say, sure, we'll apply the vested rights doctrine to that kind of permit. That doctrine's been significantly limited over the last recent years, and right now the courts have come to the point where it's like the vested rights doctrine will only apply to permits designated as subject to the vested rights doctrine under state statute. And there are three types of permits, technically two in development agreements, but first is the building permit applications, second are subdivision applications, and third are those development agreements. All the other types of permits we're talking about, conditional use permits, variance applications, shoreline, are not subject to the vested rights doctrine anymore. And so, you know, what's pertinent then in terms of how vested rights doctrine is applied in this state is what do they apply to? Because the issue in this case is, do they apply to federally mandated local stormwater regulations? So you look at the statutes that create that vesting for the subdivisions and the building permits to kind of try to figure that out. 1927-0951 applies to building permits and basically says that a valid and complete building permit application shall be considered under the building permit ordinance in effect at the time of the application and the zoning or other land use control ordinances in effect on the date of the application. For the subdivisions, under 58-17-033 provides that a proposed division of land shall be considered under the subdivision or short subdivision ordinance, and zoning or other land use control ordinances in effect when you've got your complete application for your subdivision application. So the legal issue then is, I mean, we know that stormwater regulations, that they don't fall under zoning or the building permit ordinance or the subdivision ordinance. Obviously, it's does a stormwater regulation adopted by local ordinance qualify as a land use control ordinance under 1927-095 or 58-17-033. Now for 3670B180s for development agreements, they don't use the term control ordinance, they use the term development standards. So similarly, you know, for the purposes of the development agreement statutes, do those stormwater regulations qualify as a development standard? All right. So what is a land use control ordinance? Okay, so up until this point, like I mentioned before, the Court of Appeals analysis has been the same as that of the Supreme Court. And where the Court of Appeals took it is, they looked at prior case law and they said, well, a land use control ordinance is any ordinance that has a restraining effect on the use of land, that basically restricts what you can do with that land. And obviously stormwater regulations, you know, do restrict what you can do with land because it has impacts on the amount of impervious surface you can have. It also takes up portions of the land, of the property that you want to develop. You have to put a stormwater detention facility here, you know, the swale here, those kind of things. Obviously has a restrictive impact on the use, a restraining impact on the use of land, and there's even prior case law that held that effect. So our Court of Appeals was, you know, under established principles of interpreting what a land use control ordinance, was able to easily find that a stormwater control regulation is a land use control ordinance and therefore subject to the vested rights doctrine. Well, our Supreme Court, in this case we're dealing with today, decided not to go that route, actually. They didn't investigate whether or not this has a restraining effect on the use of land. They decided we're going to look at the legislative history of and the prior judicial history of the vested rights doctrine to see if this is really directed at regulations that come from the state and federal government. And you know, they look at a Senate bill and a Senate bill report, and that notes that the vesting statutes were based upon early vesting law, which in turn were directed at controlling local discretion. And the first case that I think dealt with vesting in the state of Washington was Ogden back in like 1954 or something. And as the court looked at Ogden and said, and this is quoted from the court, Ogden suggests, the Supreme Court that we're talking about today, that court said, Ogden suggests that once a developer's rights vest, local ordinances must apply to all developers alike. Our more recent precedent supports this proposition, noting that the vested rights doctrine is rooted in notions of fundamental fairness. The legislature's reliance on Ogden thus suggests that the legislature understood the vested rights doctrine as curbing local discretion where none was warranted. And just a little more information on Ogden, you know, our vested rights doctrine coming from Ogden was based on essentially what amounts to an equal protection clause, privileges and immunities clause in our state constitution, based on the principle that all developers had to be treated fairly. And the court found, you know, in Ogden there to be a violation where a city or county would treat some developers differently by changing the rules on them after they'd submitted a complete application. So that's essentially, you know, the constitutional basis and source of the vested rights doctrine. And another thing the court looked at was if you look at our state's vesting statutes, you know, they define what you need to have a complete application, and SEPA information is not included in there. And this was, the court found this was consistent with the WAC rule that provides that SEPA policies, and I didn't know this actually until I read this case, that SEPA policies used to mitigate a project are those in place at a time a DNS or DEIS is issued, not when a complete application is submitted. So our state legislature in its vesting statutes has always recognized that SEPA, which is a state-mandated environmental law, is not subject to the vested rights doctrine. So that's another piece of the puzzle that the court found compelling. And finally, the third piece in the puzzle that the Supreme Court found compelling is that the statutes dealing with the MPDES Phase 1 and 2 permits indicate that the legislature agreed with the vesting clause in there. The legislature amended 9048-260 to dictate that DOE implement the Phase 2 permit, which includes that vesting condition. And the final bill report expressly acknowledged that the Phase 2 permit had timeframes. Remember that 2020 and 2022 clause I showed you for implementation. So the legislature knew about this vesting clause and still adopted a statute afterwards telling cities and counties, and Department of Ecology, you got to implement these requirements. So based on all that, our court basically decided, well, the vested rights doctrine was put together to curb, local inappropriate discretion where they were discriminating against developers by changing the rules on them. So that kind of policy basis doesn't apply to state mandated and federally mandated requirements because those, of course, aren't controlled by the local jurisdiction. And for that reason, therefore, our Supreme Court decided that the vested rights doctrine would not be considered as applying to, those federally mandated vesting requirements. A second holding, and this was done really fast in the case without any analysis, is they said finality doesn't apply. Snohomish County, one of the arguments they raised in their case, because they were trying to argue that the vested rights doctrine did apply, they said, well, what about the fact, that you've got all these building permits and things issued where stormwater, systems have been approved or whatever. How can you revisit those? The 21-day appeal period is over. I mean, it's set in stone at this point. And the court said, without, like I said, saying much, no, the Pollution Control Board never gave any credence to the finality doctrine as it applies to stormwater regulations, so we're not going to either. So, that was a big issue of concern for a lot of developers out there who are like, geez, we've got our developments approved, we haven't started construction yet. You can't possibly think that now, a year or two after we have our building permit in hand, you can change the rules on us and tell us we have to put in a whole different detention system. But, Supreme Court apparently, if you read its decision literally, says, yes, you can. So now one thing to keep in mind with this decision, this is very important, is that specifically, it doesn't mean that you're applying your new stormwater regulations to every new project that you've already approved or that's already vested. You have to apply that condition in the MPDES permit that says it only applies to projects applied to before July 1st, 2015, where they still haven't started construction prior to June 30, 2020. And similarly for the Phase 2, it's those that were applied for before July 1st of 2017 and haven't started construction prior to January 2022. So I'm kind of say opening the Pandora's box. Well, okay, we have, the EPA tells us we have to adopt these certain these new stormwater controls. DOE then adopts this permit that says we have to incorporate them in the local ordinance. That's not subject to vesting. That's very similar to the state legislature adopting updates to the Growth Management Act and telling cities and counties they have to implement it into their comprehensive plans. Even what about the 5-year, 7-year growth management updates? Those are state mandated requirements, right? Is that going to be considered a state mandated regulation that therefore is not subject to the vested rights doctrine under the analysis of the Supreme Court case there? I mean, you could make that argument. I think it probably wouldn't apply just because if you look at the Growth Management Act statutes, a lot of you are probably familiar with the interim and emergency ordinance provisions. Those statutes were adopted because the legislature recognized that if they didn't have something like that and they had that critical area requirement in there, that all the developers would rush in to vest their applications before those new critical area ordinances were adopted. So by virtue of the fact that our legislature recognized vesting and incorporated prevention measures to prevent developers from vesting against state mandates, it looks like that that scenario is already incorporated in there, and then maybe we don't have to worry about it. Also, because this raised so many issues for developers and jurisdictions alike. You know, they went back to the state Supreme Court and said, you know, really, do you really mean everything you said in your case? The Supreme Court in response on May 2nd amended their decision. Didn't look like the amendments were really huge, except at the very end of the decision, they threw in a footnote, I think it was number 8. It says, our conclusion with respect to the 2013 Phase 1 permit should not be interpreted to suggest that all federal and state-directed environmental laws are exempt from vesting. So they went through this whole 20-page decision, essentially concluding that state-mandated and federally mandated environmental regulations aren't subject to the vested rights doctrine, and then they stuck a footnote at the end saying, well, maybe it doesn't. So, you know, it's I think the court is basically telling us we really just want to limit our holding here to the MTDS situation and you know, wait and see what happens in future court opinions for these other types of scenarios. But definitely an important case, and even those of you in Eastern Washington now, you've got to deal with a little bit of confusion created by this case in terms of, you know, if you're dealing with updates to regulations that come from state and federal mandates, you know, is that subject to the vested rights doctrine or not? We don't know for sure anymore because of this case. All right, Burien 2, the money sequel. The reason I'm referring to Burien in this case is that in 2007, there was a case that it was Burien versus Windmark Development or some similar sounding development corporation, where the city of Burien ended up paying a $10.7 million judgment for essentially engaging in permit review that initially took 3 years, and then after some settlements reached, caused delays of another 5 years, 8 years total to approve 175 unit apartment building. And because of those delays, and because it appeared that you know, the jury anyway came to the conclusion it was done because for political reasons as opposed to reasons based on the code, you know, they found some tort liability, and they issued that $10.7 million judgment. Well, yeah, you know, since that case came out in 2007, I haven't seen any other major monetary judgments in the Court of Appeals decisions until about a month ago that this Maytown Sound and Gravel versus Thurston County case came out. This case involves a $12 million judgment for the same reasons, same types of reasons that applied in the Burien case, where at least it appeared to a jury that a developer was kind of dragged about for reasons that dealt with political issues as opposed to issues firmly grounded in the code. So I'm going to go through this case in a bit of detail and point out you know, some of the things that were done that led to liability, and maybe throw in some pointers as to how to avoid that liability, because you know, it's just that's a lot of money to have to pay, and not something you want to see happen too often in these appellate court decisions. So, all right, let's get started in the facts then. Starting in 2006, I mean, ultimately the facts that led to the liability occurred in 2011, which is 6 years ago. So it took a while for everybody to finally get to final resolution at the Court of Appeals level. Of course, it could still be appealed to the Supreme Court, who knows, and maybe I'll be back here a year from now saying it's been reversed. But right now, at the Court of Appeals level anyway, that $12 million judgment was sustained. So in 2006, Thurston County issues a 20-year special use permit to the Port of Tacoma for a gravel pit operation. Those of you working with gravel pit operations probably just grown at this point. Those are always a big headache for jurisdictions dealing with them. And that gravel pit special use permit included a condition requiring 5-year review by a hearing examiner. So every 5 years, the hearing examiner is supposed to look over it and make sure that you know, that the pit was being operated as conditioned and whether anything new had to be done to it. There's a condition 6 attached to this special use permit that required adherence to a groundwater monitoring plan. Groundwater is always a big deal when you're dealing with gravel pits. Condition 6A required verification of off-site supply wells within a year of approval of the SUP, and Condition 6C required installation of 17 monitoring wells within 60 days. The port didn't comply with any of those deadlines. So in 2009, Maytown Sound and Gravel, MSG, meets with county staff to discuss that special use permit in anticipation of purchasing it. So the county, and this was somebody in management of the county, advises Maytown that, yeah, the SUP is still valid, but we need some minor staff approval and things need to be done in order for it to move forward. The management person also advised that all the revisions necessary for that permit could be handled administratively, and that MSG could be mining, heck, within 30 to 60 days. You know, get your shovels out, you can get going. So based on this, assurance from Thurston County, MSG enters into a purchase and sale agreement to buy the gravel pit for $17 million. Then a little later, in December 2009, the county emails the MSJ to let them know that, well, actually there are some compliance issues. I think this was the deadlines that were missed. And but the staff could approve minor amendments, or maybe it'll have to go to the hearing examiner to approve them as major amendments. We don't know at this point. Then the court opinion doesn't mention what happened between December 2009 and February 2010, but in February 2010, probably at the prodding of MSG, the county then sends MSG a detailed memo, reviewing all the conditions of the SUP and finding that all the needed amendments could in fact be reviewed administratively. You won't have to go through that hearing examiner process to deal with the deadlines that weren't met. We can put in new deadlines. It should be easy to move forward, no problem. So based on that memo then, in April 2010, MSG goes ahead and closes on the purchase and sale agreement. They put down $1 million deposit, and after off they go. So but after closing in April then, MSG requests 8 amendments to the SUP, including those amendments to condition number 6 that I've been talking about. They specifically requested that those deadlines be revised, to reflect the fact that Tacoma didn't meet them and MSG wants to meet them themselves. And, MSG submitted these amendments based on the assurance that they'd be handled administratively. But now the county says, oh, actually, no, these are major amendments and it's going to require hearing examiner review. And according to an attorney for MSG, he was told by somebody at the county level that this new position from the county came about from advice issued by the attorney for the Board of County Commissioners. Now, the Board of County Commissioners isn't involved in day-to-day permitting for Thurston County, and neither is their attorney. That was not his place to, interject his opinion into the local permitting process and say that a different process had to be used. That's one of the first bad things that happened in this case. So based on the directive from the attorney for the Board of County Commissioners, the hearing examiner then holds a hearing on those amendments and approves them actually. So MSG is still good. So in the meantime, we also have the 5-year review coming up. Going on a little detour here. So in 2010, in anticipation of that 5-year review, the county issues a summary report pending that 5-year review that basically concludes that, since no land disturbing activity has yet occurred, apparently that there really hadn't been any digging done yet, that the new critical areas ordinance should apply, a 2009 CAO should apply. So the county takes this memo, takes that position before the hearing examiner at the 5-year review, and the report essentially was saying that complying with the new critical areas ordinance could result in a loss of mining area of up to 100 acres. The hearing examiner concludes that the new critical areas ordinance doesn't apply. There's no reason to change the conclusions of the critical areas review that was done when the SUP was initially approved back when it was first approved, and everything was fine. They could just still move ahead. So 2 environmental groups don't like the results of what the hearing examiner came up. They filed an appeal to the Board of County Commissioners. 2 of the 3 Board of County Commission members were members and donors of one of the environmental groups that appealed. And then after this appeal gets started, the Board of County Commissioners directs staff to evaluate whether the permit was still considered active or valid because it hadn't been mined yet. And that's also a big no-no because the BOCC usually doesn't direct its staff on permitting issues. All right, this is kind of even separate from the appeal. They were looking for ways to kill the project, essentially. At least that's the way it was written up in the court decision. Also, then the Board of County Commission members start holding private meetings with the chair of one of the environmental group appellants to discuss the special use permit in the gravel pit. After learning of the environmental group's position on the special use permit, one of the BOC members then expresses an interest in reopening SEPA and even invites the environmental groups to have a meeting with the Board of County Commissioners without the applicant there, although the Court of Appeals decision on this was unclear whether they actually held that meeting or not. Another BOCC member signs a petition to rezone a part of the MSG property, presumably so that they couldn't mine it. At the appeal hearing then on March 2011, none of the BOCC members disclosed their meetings with the chair of the environmental groups or their membership in the environmental group as well. So the final decision from this 5-year review is that the BOCC remands the a 5-year review back to the examiner saying he has to review a supplemental habitat plan, which shows that there might be some new critical areas that weren't discovered when the SUP was first issued, and that could then, reduce the area that's left for mining. Well, you can imagine that MSG is maybe getting a little sick of this at this point, so they appeal the BOCC decision under the Land Use Petition Act, and they also file a claim for damages. At the outset, the Superior Court reinstates the examiner's 5-year decision, says that was valid. All the stuff that the Board of County Commissioners placed on that 5-year review during their appeal was invalid. We're just going to stick with the examiner's decision that there's no need to change the terms of the SUP permit. Everything's fine. So MSG then moves on to their damages claim. And they raise several damages claims. The big one here, I think, and this is the same one that we dealt with in, I got my 5-year already, my 5-minute already. The big claim on this one is the same as the one that was raised in the Burian case, which is a tortious interference with business relationship. This is a perfect tort claim for dealing with politically motivated land use decisions. And basically, the elements are that a party claiming tortious interference with a contractual relationship, A, has to prove the existence of a valid contractual relationship or business expectancy. In this case, as with all permit application, the business expectancy is that once you get your permit, you're going to be able to go develop your property and sell it and make tons of money, or in the case of a gravel pit, you're going to be able to go out and start mining and make tons of money there. 2, the defendants have knowledge of that relationship. Well, obviously Thurston County knows, the applicant wants to mine and make a bunch of money. That's why they're there. And 3, an intentional interference inducing or causing a breach or termination of that relationship or expectancy. Well, in this case, it was a delay of that expectancy where they required the MSG to spend all this time going through in front of the hearing examiner for what should have been a minor amendment, but they had to do it as a major amendment to amend the conditions of approval, and also they had to go through that 5-year review and get that erroneous decision saying that critical areas had to be considered once again. So that was the intentional interference with their right to mine that property under their permit. And this is the big one. The defendants interfered for an improper purpose or used improper means. Now, obviously, if the county had been justified in code to say you have to revisit the critical areas ordinance, or the county had been justified in code to say that you had to go through the major amendment process, that wouldn't be construed as an improper purpose or improper means. But in this case, since there were all these illegal meetings going on with the appellants, and there was a lot of what the court, I should say the jury anyway, thought was biased, there was improper purpose and improper means being employed. And that's the linchpin criteria here and why they got in trouble. And of course, the resultant damage for MSG was delays in getting out there and developing. So now on the tortious interference claim, the county defense was, and this is, there are several elements, but essentially they said that when the hearing examiner issued his first decision, this isn't the 5-year review, this is the decision approving the amendments that extended the deadlines for the monitoring wells. When he made that decision, he didn't find any improper purpose or motive. He said he found that staff had properly used their discretion to determine that the major amendment process, as opposed to the minor amendment process, was the proper way to go. And so the county said, well, A, the 21 days is up on that decision. It was never appealed, so it's set in stone. And B, through the doctrine of collateral estoppel, which means once you've litigated an issue, you shouldn't have to relitigate it. It's a done deal. We're done with it. And the court disagreed essentially and ruled no. The hearing examiner didn't address the motives behind the county's decision for making MSG go through the major amendment process. So, it's okay that we reconsider the motive or actually address it for the first time in a damages claim, and we'll allow MSG to move forward with that claim. Now, the second damages issue, and I'll speed this up a little bit, was, and this is, whenever you see a damages claim, there's always tortious interference with a business expectancy, and 2 is, a violation of constitutional rights. That's done through 42 U.S.C. Section 1983, which provides that whenever, a state agency, which includes cities and counties, violates the constitutional rights of somebody under color of state law, that they're entitled to damages for that. And so MSG is claiming their due process rights were violated because they were required to go through processes that didn't apply, and they were required to, they were being subjected to critical ordinances that didn't apply. That's not, consistent with due process, which is essentially, nor shall any state deprive any person of life, liberty, or property without due process of law. And the courts, I'm going to skip over to, one of the important parts of that analysis is that, if I can find that here, yeah, is you must prove that the property right that's deprived, it was done in a shocking manner. And so because these decisions were made by Thurston County in a manner that at least appeared to a jury to be politically motivated, the court found that sufficiently shocking to be a constitutional violation under Section 1983 claim. So some takeaways here, we all know, we're all very familiar, I'm sure, with appearance of fairness, and there are defenses to that. Like in this case, if the Board of County Commissioners had disclosed those violations, they would have all been able to stay, for at least some of them, simply because under the doctrine of necessity, they wouldn't have a quorum without it. So a lot of the things that happened there, if it had been properly disclosed, wouldn't be considered violations of the appearance of fairness doctrine, but would still lead to liability under tortious interference and under constitutional violations, because it could be considered shocking or an improper purpose or that kind of thing. So, appearances really matter a lot of these things, and you really, not just for appearance of fairness, but for liability under those, the tortious interference and the due process violations, it's important that you look impartial, that you look objective, and that you base your decisions on the code, because otherwise it's going to cost you a lot of money. And the other thing too is, whenever anyone comes up to you at the counter and asks you for advice on whether or not, they could do this or that with their property because they're thinking of buying it, that's a huge source of liability. Cities and counties are forgiven for a lot of negligence and mistakes in the permitting process, but one that they're absolutely not given any slack on is for giving bad advice to potential property owners. So someone comes to you asking for advice, make sure it's accurate. I would advise, in some cases, it's something to talk about with your city attorney. If you know someone's thinking of making a multi-million-dollar purchase, that you issue an appealable formal interpretation. Because you do that and the appeal period expires, even if you were wrong, that's still set in stone, nobody can change it, and then there's not going to be claims later on that, bad advice was given and that kind of thing. So let me jump on to, going to give myself 2 minutes here. Chumbley just dealt with, as I mentioned before, don't even look at the screen here, but Chumbley dealt with a situation where a city issued a building permit for a house that involved an off-site drainage improvements for a septic system. The building permit application mentioned there were going to be some off-site improvements, but there were no site plans or anything that identified the site plan improvements. There's nothing about design mentioned in the application. And that particular city also had a steep slope ordinance under the critical areas ordinance that would have required a separate critical areas permit for these off-site drainage improvements as well. So the permit applicants, they get their building permits to move forward and everything else, and this upsets the neighbors and the DL Railroad, which is right underneath, because this drainage is draining into some steep slopes that have a potential of creating a landslide onto an adjoining railroad track, which didn't make the railroad very happy. It didn't make the adjoining neighbors very happy. But they filed their appeal more than 21 days after the building permit was issued. So of course the city that issued the permit and the developer's argument was, well, more than 21 days have elapsed, the building permit was issued, they should be able to move forward. But the court said no, since those separate drainage improvements weren't specifically identified in the building permit application, and since a separate critical areas permit was never applied for, that 21-day rule won't apply here. And what was interesting in that case is that the court did find a decision-making point. The city at one point actually did decide, oh, maybe they should get a clearing, critical areas permit for these off-site drainage improvements. So they started a code enforcement action, but then they dropped that code enforcement action once the developer made some improvements which prevented the drainage, which destabilized the slope. And the city then put a notation in its case activity log saying, we're dropping this because the developer has fixed the problem. The court in that case said that the 21-day appeal period started from the date that the city entered that notation in their case activity log, showing that the code enforcement action had been dropped, because the court considered that to be the final land use decision from the city, deciding that they didn't need to get that critical areas permit for that kind of development. And the appellants in that case had filed within 21 days of that decision, so they were good to go. Finally, on giving my 1-minute take on the Vancouver case, there it is, reasonable alternatives. I think that the important takeaway on this case, what's most pertinent to cities and counties, is that, and let me see if I can pull up the regulation here. Here it is, yeah. WAC 197-11071 says that until a responsible official issues a final determination of non-significance or final EIS, no action concerning the proposal shall be taken by a governmental agency that would limit the choice of reasonable alternatives. A lot of you are probably familiar with this. It's just the idea that, SEPA is there in order to ensure, informed decision-making of the environmental consequences of what you do. So obviously that SEPA review needs to be done before you make those decisions, and that's pretty much what this WAC is saying. What happened in this case is that the Port of Vancouver entered into a lease to allow this huge petroleum refining and storage operation to be located close to the shores of the Columbia River. And the appeal is based on the argument that the port should not have entered into that lease before an environmental impact statement that was in the works had been completed, so the port could decide whether or not it was good for the environment to allow this facility to be located on their property. The court ultimately ruled in favor of the port on this case, ruling that the lease had an escape clause that said that the final design location of that petroleum facility was subject to the approval of the port. And the court said, well, they still, this didn't limit their choice of reasonable alternatives because they could still theoretically say, no, this is not appropriate location for this in our port facility. It's a little suspect. I mean, I think it strained the escape clause of that lease to say that really that the port could just categorically say, no, we're not going to allow you to build it here because the EIS has shown us it would be bad for the environment. But that's the way the court interpreted that escape clause. So for those of you anyway who are in the leasing business or something, I mean, if you have a good escape clause in there that ultimately lets you get out of a lease if it looks like that information from an EIS might say it's a bad idea, that'll keep you out of trouble with 197-11070. So with that, I'll now leave it to Jill to go over her report.
Thank you, Phil. I'll just advance the slides. All right, so Reed versus Gilbert, the now infamous sign code case. This was decided back in 2015, and it continues to generate a lot of questions among jurisdictions with regard to both regulating signs and other local regulations that may implicate the First Amendment. A quick overview, Gilbert is a town in Arizona, and the town of Gilbert sign code prohibited the display of signs without a permit. However, it exempted 23 categories of signs. These categories were then regulated differently, and those at issue in Reed were ideological signs, political signs, and temporary directional signs. And Reed was a pastor, and his church utilized temporary directional signs to direct the members of the church to the church because it had different locations it would use each week. And the town enforced upon them, and the pastor Reed brought a challenge, and it went all the way up to the Supreme Court, and ultimately 9 justices unanimously agreed that the sign code violated the First Amendment, although it generated 4 separate opinions. And they held that the sign code's different standards for different categories of non-commercial speech were content-based. And content-based regulations are presumptively unconstitutional, and a strict scrutiny test applies. And the majority adopted a really strict test for determining whether a regulation is content-based. Basically, if you have to read the sign to enforce the code, then it's content-based. So what's happened since Reed? A lot has happened, and there's some more clarity about how courts are interpreting this, but still a lot of questions. Generally, if a court has found that there's any distinction among regulations based on the content of the sign, those codes have been consistently struck down. I have a few examples of those decisions underneath, and there's several more too. However, recently the Federal District Court of the DC Circuit Court issued a decision in January that maybe provides some wiggle room, or at least maybe loosens Reed a little bit. It's not a U.S. Supreme Court case, but it maybe gives an idea of how it can work within Reed to allow some differentiation among sign types. So in this case, the Washington, D.C. sign code applied durational limitations to event-based signs on lampposts, but did not apply those same durational limits to non-event-based signs. The plaintiffs challenged that, and the D.C. Circuit ended up upholding this distinction. And I have quoted some language from the decision there. Basically, they felt that it was a common sense distinction and it had nothing to do with viewpoints or subjects. They rejected the plaintiff's urging to apply the need to read standard that was sort of implied in Reed versus Gilbert. Also, since Reed, generally content-neutral regulations, many have been upheld as reasonable time, place, and manner restrictions. One such example is in the case of Lone Star Security versus City of Los Angeles, the Ninth Circuit case, and they held that a ban on certain types of mobile advertising billboards was okay. The plaintiffs argued that advertising was a content-based distinction, but the court disagreed. They felt it was content neutral, and that ultimately the ordinance left open ample alternative communication channels. And I'm sort of rushing through these because we're short on time, but I may go over the hour a little bit, but I'll do my best to get it done quickly. One thing that courts now have consistently not applied Reed versus Gilbert to commercial signs. Instead, it looks like the Central Hudson test that was set forth by the United States Supreme Court in 1980 remains intact. And it's a three-part test, and it's a lesser standard than a non-commercial speech sign. Reed has also had some impact on non-sign related codes. One example here in Washington, and it's, I think, been consistent in other challenges throughout the county, or country, excuse me, is the striking down of panhandling ordinances that target a specific type of speech. In this case, the City of Lakewood ordinance targeted begging, a specific type of solicitation that involves asking for money. And the court applied Reed to this to hold that that was unconstitutional content-based restriction. I've found that there's a sign law resource that I found really helpful, www.rockymountainsignlaw.com. It's maintained by a land use law firm in Colorado, but it's a really good source of keeping up to date on First Amendment cases that affect both sign regulation and other land use regulation. And you can search by key terms such as content neutrality and political signs. So if anyone is interested, I recommend that. And we get a lot of questions here at MRSC about what people are doing in response to Reed, and honestly it's been a pretty slow reaction. I think people have done a lot of waiting and seeing to see what other people are going to do. But to date, I know that Edmonds, Bremerton, Kirkland, Rainier, they've all adopted codes in response to Reed. And there's also an Association of Washington Cities model ordinance that's out there. And I'm guessing there are others. So please let us know. If you wanted to in the comments, you could let me know if you know of other regulations that have been passed, or feel free to email me. And finally, I'll talk about Whatcom County versus Hearst. And I'm guessing most people are familiar with this case as well. In this case, Whatcom County had adopted comp plan and development regulations, and those were challenged by FutureWise and others who argued that they failed to protect water quantity and quality, and also failed to ensure that there was legal water available for building and subdivision permit applications. So ultimately the Washington State Supreme Court agreed that their comp plan and development regulations did not comply with GMA. In Whatcom County's case, they had relied upon Department of Ecology's Nooksack rule, which was an in-stream flow rule for issuing or for showing that they're meeting their GMA obligations. And the court held that counties have a duty under the GMA to make determinations of water availability and to protect water quality, and they can't simply defer to ecology rules to satisfy those duties. And water is not available for withdrawal from permit-exempt wells if in-stream flow rules are not being met for all or part of the year. So quickly, I'll talk about whether there might be a legislative fix and also some county responses. At the beginning of the legislative session, a number of bills were introduced that would have addressed Hearst in some manner or another. As far as I know, only two bills are being considered in this special session, and that's a Senate Bill 5239 and a House Bill 2226. The Senate bill would amend the GMA and other statutes in response to the Hearst decision and would essentially bless what Whatcom County had done before, which is rely upon ecology's rules to satisfy their GMA obligations, a practice that the Court of Appeals had indicated was sufficient. Here is sort of a summary of what the bill does. One significant thing too is that it would allow for the mitigation of impacts to fish or habitat rather than requiring no impairment of flows. I believe this is getting at the Foster decision, which requires that mitigation be in kind and place, I believe. So this has passed the third reading in the Senate, and so it is still active. And then we have House Bill 2226, and this was just introduced this week by the House Democrats, and it's generally consistent with the the Washington State Supreme Court's Hearst ruling, but it goes further to kind of set up a mitigation program. It does so for water resource inventory areas with pre-2001 rules like the Nooksack rule. Generally, the rules adopted after that date include reservations for domestic uses and mitigation programs within them. It also requires areas that don't have any in-stream flow rules to implement mitigation programs. So that goes beyond Hearst. Also requires that 20-year growth projections for GMA planning jurisdictions take into consideration current scientific information on water availability. And it also requires that ecology assist by trying to obtain rights to mitigate the withdrawals in time and in place, and where it can't, it'll convene a mitigation committee who will have to unanimously agree on mitigation for withdrawals from exempt wells. There will be a mitigation fee, also a requirement for water meters, and it does create a new private cause of action. And the likelihood of success, I am not sure. I understand that there is a meeting to discuss the two different bills this week. However, the two bills are quite different in nature, so it's not clear what, if anything, will ultimately be passed. So county approaches, I realize it's one, so I'll just be very quick here. They generally fall into four categories. One is jurisdictions who have adopted interim ordinances relating to issuances issuance of permits relying on permit-exempt wells. Other jurisdictions are doing sort of a buyer beware approach. In other words, if someone comes in to obtain a permit that would rely on an exempt well, they will issue the permit, but with the proviso that this may not be legally available water. Kind of proceed at your own risk. And then there's other jurisdictions who are just waiting to see what the legislature might do or what other counties might do in taking the lead. And then there's some, like Kittitas County, who are already Hearst compliant because they've already dealt with some litigation surrounding their decisions surrounding permit-exempt wells, and so they've already put in place programs like water banking and such. So what I had done is gone through some details of Whatcom County's approach. They basically require a showing of no impairment or a mitigation plan. Similarly, Spokane has adopted interim regulations that require no impairment in their area affected by the in-stream flow rule, and outside that area they have a little bit more of a flexible standard. And King County is sort of a buyer beware approach, but they also believe that Hearst is a GMA case, and really it's about the duty occurs at the time of the next periodic update when planning jurisdictions need to update their codes and comp plans under GMA. At that point, they need to show how they're going to provide for water availability. But they also provide a special notice to landowners that basically proceed at your own risk. And again, Kittitas County is already Hearst compliant. And now for questions. I don't see that there's any questions here.
Well, that's good. So I guess we're done, right?
All right, well, thank you for joining us. Please feel free to email either Phil or me with any questions about the webinar today, and we should have the contents of the slides on our website, MRSC's website, soon. So the stuff we had to kind of skip through, you can go back and look at.
All right, thank you.
Thank you.